by constitutional means. If you're sure of the outcome, if you're sure of your case, if you're sure of your influence, and you feel that injustice is going to be meted out against you, one of the things that you're expected to do is to ensure that you calm the frayed nerves of your supporters, and then seek redress by constitutional means, to go to court and seek a reversal of whatever has been done against your person or against your incumbency. Now, it is not foreclosed. That's why you have election petition tribunals. Decisions have been taken. These decisions can be reversed at the election petition tribunal. If you lose at first level at the election petition tribunal, the appeal court is there. The Supreme Court is there.
Mr. Quakers.
So why should we?
Does INEC have the power, or for lack of a better word, to say, this fellow hasn't gone to the right court, so I'm not going to go to court?
No, you can't do that. That's calling for anarchy.
Okay. Yeah. Secondly, what power or what is the potential for this process, this legal process, to tamper with the results of the elections? Well,
the results, from what I said earlier, Section 53 of the Electoral Act is clear. The result has already been collated. But if INEC, in its wisdom, feels that a particular polling unit or area has experienced overvoting, in other words, suspects some rigging in that neighborhood or electoral, INEC on its own can determine that, look, because of the outcome of the result from this polling unit, we will not organize any election there. We will postpone the election or suspend it until we look into it. But if INEC now feels that if we cancel the election in that neighborhood or that polling unit, but it will not affect the general outcome of the election in the constituency, what INEC will do is it will go ahead and declare results. But if it feels otherwise, there will be no return until there is the...
You explained that earlier, and I understand that, but does this process of taking INEC to court, suspending the process, and does it have any capacity to affect the results that INEC already has in its kitty?
Well, it depends. It depends. Except what we're looking at, I want to believe the best of the institution because it is an independent institution. The question I ask myself is this: why would an incumbent governor seek immediate judicial intervention when the election is yet to be concluded?
But first of all, isn't it within his right to do so?
First question is he aware of the outcome?
Exactly.
Does he know the results?
No, can't I say, look, in a view to prevent maybe an outcome that I think may be,
is not
or if the process is going to be manipulated against me, if I think I'm not getting what I deserve, I can proceed to court.
It's an academic exercise because infraction has not occurred for you to seek redress. You're just conjecturing facts. Part of what we say in law, for instance, before you can seek an interim order, it should not be self-imposed. It must be real.
Do you think he knows the result?
That's why I'm saying that on what basis?
Well, we
don't
know what he knows, right?
Yes,
I'm just wondering, Mr. Quakers, I'm just wondering what the whole essence of the process is, because the way it's looking is like you're just delaying the process and, pretty much wasting, everybody's time, so to speak.
Said that he has the right to feel
if
he's not comfortable.
And the court has the right to hear him.
No, it's a right in context.
No, let's put it this way. And that's where some of us have always said it consistently. When the law is clear, and you have judicial pronouncement on this issue, that election can only be challenged at the election petition tribunal because the issues you're raising are post-election issues, and that the appropriate platform or forum to go to ventilate your grounds or seek redress is at the election petition tribunal, not in the court. Not in the regular court.
Hold on, guys. Will this be, because we have to get this straight. If in the case of Honore, it was the CCT that heard it, instead of the where they're supposed to take it.
The matter is ongoing anyway.
It's ongoing, but it was supposed to have been in another place, according to you lawyers. What makes the case different in this one?
No, it's different. I'll give you an example. The power in relation to non-declaration of assets or under-declaration of assets in relation to the code of conduct for judicial officers, the only competent institution.
You say it's the NJC?
No, it's not the NJC. It's actually the
CCT.
the CCT. But before the CCT can exercise its jurisdiction over the subject matter, because you're looking at the judicial officer, whatever complaint you have must first be placed before the NJC, before the CCT spark.
So that's
okay.
Equate that to this process. Where do we go first? Where do we go? Where do we address? Where should the governor have first gone to?
The governor should have gone to the election petition tribunal. You wait for the outcome of the result. You wait for INEC to finish exercising the power conferred on it by the enabling law and also by the constitution, and then you now go to seek redress.
Which begs the question,
Yes.
why this process?
That's the question, because the question I also ask myself is he aware of the outcome?
Yeah,
if he's aware of the outcome, how did he get to know?
Yeah, but should we then be worried? Because
We should.
This is a law court here. They know what the law says.
Yeah, we should.
Should we? Why should we be?
We should be worried. Worried in the sense that it's like you're trying to nip in the bud a process that should be allowed to run its course. And if you allow this to stand, it means every governor, any politically exposed person, an incumbent in office, can truncate the judicial process, can truncate clearly unambiguous provisions of enabling laws. You now subject institutions to the whims and caprices of individuals. It's something that should give every Nigerian
But there's already a
concern.
precedent. I mean, it's also there in law that post-election matters end up, the place for that
Yes.
is the tribunal.
Yes.
So if he's going to the regular courts and there are precedents about that, I asked you, will be worried because, look, eventually he will be referred to the tribunal. Wouldn't the matter be referred to tribunal?
Look at it this way. Look at it this way. Time will be wasted. Now, INEC should have declared the result. INEC is unable to declare the result because someone has gone to court. INEC, by law, has a duty to appear in that court. And INEC has said, we will obey, we will not disregard this order with contempt. We will not disregard it. We will go to that same court to seek to set it aside. Now, INEC is also going to incur cost for going to that court, because INEC is going to engage the services of a lawyer to go to the court to seek to set it aside. Mind you, the judge adjourned the matter for hearing of the substantive case. So I want to believe what has been filed is by way of originating summons.
So maybe that's where you say we should be worried, because
Yes.
I think I also remember that he was saying that INEC, if they couldn't prove why that case shouldn't be heard, then they were talking about a substantive matter. So what you're suggesting now is, ordinarily, they should have heard INEC challenging jurisdiction first before going into substantive matter.
No, but
How
you
should they
see,
have worked?
no, see, INEC was notified of the order from what Ahmed Rajesain said. Now come to this court and show cause why the order being sought by the applicant should not be made. Now INEC didn't show up. The court now on its own now ordered status quo ante bellum to be maintained.
Which is what was on before they came to court. In the first
Exactly.
place.
So in other words, you're yet to declare the result, don't declare the result.
Okay, in looking at the substantive issues now, what does that mean? Is this a prolonged process? Are we in for a long time?
No, not really. It's not a prolonged process. You're expected to go. INEC has already gone. INEC will probably file, because election matters in regular course and also election petition tribunal have time frame. For instance, if I have to file a petition, election petition in in the tribunal. I have 21 days to do all of that. The tribunal also has a period within which to finish all of that. Same thing with regular courts. You don't want to truncate a process by stalling. Now, the judge is duty bound to hear it one way or the other, and the issue that has been placed before him is an issue of law that does not require time-wasting mechanism. He has to pronounce on what has been filed before him or placed before him one way or the other. But some of us just feel that, look, you should not create commotion and chaos where it is not necessary.
Is it temperable? Can they, as Ayo asked before, let me ask you again. Because I'm really wondering
You're not satisfied with that answer.
I'm not satisfied. Because Ayo asked that, can the results be tampered with?
Can the result be tampered with? Do we know the result?
No. Can the results that has not been declared,
the one with
can this court process do anything about it?
No, but the question you also ask yourself is, has INEC declared the result? Do you know who has won? Do you know who is losing?
Okay.
So we're not in any position. Only INEC has that fact because it is an independent and impartial umpire. So if someone rushes to court, that means the person knows things that we do not know. And that's why some of us are a bit worried that is the process so porous that someone who is participating in the election already knows the outcome.
Well, we'll come back to this and take a look at what the implication may likely be at the end of the day. Stay with us.